During opening arguments, what do we have to tell the jury that we are required to prove in order to justify a verdict in our favor? Would you like to learn the answer? Come join me for a moment on this beautiful stretch of beach as I share with you this great answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Alright, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now the doctor disputes all of your claims, which means that your case is likely going all the way to trial. So now it takes 2 or 3 years for your case to actually get to trial. And finally, your case comes up for trial. And now we are at trial and we're ready to make opening arguments. Did you know that there are very specific requirements that an attorney must tell the jury in order to proceed forward past opening arguments? It's almost like a gate. If we can't give the jury certain information, we never get past that gate and your case will be thrown out. Many people don't know that. They don't understand that if we don't lay out what's called a prima facie case, the defense lawyer is going to jump up out of his seat as if somebody pressed an ejection button and yell out, "Judge, Mr. Oginski has failed to make out a prima facie case, and I ask that you get this case out of here and dismiss it immediately." And you know what? He'd be absolutely right if I did not lay out the elements needed in order to justify going forward with this particular trial. So what exactly do I have to lay out? What do I have to set forth in order to get past that gate so that now we can proceed forward to take testimony? I'll tell you what we have to do. I have to establish liability, causation, and damages. Now, those are 3 fancy terms that basically say, listen, I have to show the jury during opening arguments that our claim is that the doctor was careless. I have to show the jury that our claim is that the doctor's carelessness was a cause of your injury. Doesn't have to be the cause, only a cause. I also have to show that they're all connected, that the doctor's carelessness violated the basic standard of medical care, that he was careless, and that it was that carelessness that caused you harm and injury, and that your injury is significant and or permanent. Those are the 3 elements that we have to show to the jury to go forward with the trial of this case. If I simply argue that the doctor was careless and don't talk about how his carelessness caused you harm and injury, guess what? The judge would be well within his right, and the defense lawyer would be well within his right to make that objection, for the judge to actually throw this case out because we have not set forth a proper claim to establish that the jury is entitled to go ahead and evaluate this case to determine whether or not to give you a verdict in your favor. Or if I was able to make out a claim that the doctor was careless and his carelessness caused you harm, but the harm was not significant or in any way related to the wrongdoing, guess what? The defense lawyer again would be absolutely right to object, and now the judge would be correct to go ahead and throw the case out before we even start taking testimony. That's pretty harsh, isn't it? And you're right, it is. But an attorney should never be in that position. An attorney who brings a medical malpractice case at the very beginning, before we are even permitted to get into the courthouse door, we have to get medical confirmation from an expert, a board-certified, typically a board-certified medical expert, who is familiar with the facts, who has reviewed the records, who can confirm, number 1, that yes, there was carelessness, yes, that wrongdoing, that carelessness caused you harm, and yes, the injuries are significant or permanent. So if we don't have a medical expert, we're not even permitted to start your case. So let's say we do have a medical expert who confirms all those things, and now 2 or 3 years down the road, your case comes up for trial, and now the judge turns to me and says, "Counsel, you may begin your opening arguments." And now, as I'm explaining to the jury what's needed in this case, or what this case is really about, and what our claims are, guess what? If I fail to explain to the jury in detail why we believe the doctor was careless, why his carelessness caused you, the patient, harm, and why the harm is significant and or permanent, guess what? This case is going to be dismissed, and we never get to have any testimony, and the jury will never get to evaluate whether or not what you are claiming is in fact true. So why do I share this quick information with you? I share it with you because I want you to truly understand how these cases work. And if your matter did happen in New York, and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is to pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.